This is part 22 of my journey through the court system in the state of Connecticut over the last 10 years. Part 21, it cut off at the end. I was in the middle of talking about how in the March 8th, 2021 hearing that we had, and it was with Maureen Price Borland, that she completely violated all of my rights, and we were going over all the things that they did that violated my rights or were constituting perjury or fraud during that hearing. Judge Price Borland's handling of the March 8th, 2021 restraining order hearing, which again, if you haven't seen it or listened to it, you can go on my YouTube channel on Pro Legal Solutions and watch the whole thing. Her handling of that hearing transgressed virtually every layer of legal protection that governs a domestic violence case in the state of Connecticut. Her errors were not harmless procedural slips. They gutted the substantive and procedural safeguards guaranteed to a family violence victim under state statute, the Connecticut Constitution, and the 14th Amendment. Connecticut law requires issuance of a restraining order if the evidence shows a continuous threat of present physical pain or physical injury, stalking, or a pattern of threatening. The statute expressly covers coercive control and repeated unwanted contact. The record contained unrefuted exhibits that satisfied each statutory prong. The police report confirming an uninvited 3:30 a.m. break-in that was a continuous threat, screenshots of 36 blocked calls in 24 hours and 21 calls in a single evening, stalking and coercive control, emails in which Lodis vowed to have me clipped and key my car, a pattern of threatening. Instead of applying that objective test, Judge Price Borland substituted her own subjective credibility hunch by saying, "I don't find either of you very credible." She then dismissed the petition. That misapplication of Section 46B-15 is an abuse of discretion and reversible error under Connecticut appellate precedent, holding that credible fear may be established by conduct alone, irrespective of the victim's demeanor. Matthews v. Eldridge requires a court to consider the private interests at stake, the risk of erroneous deprivation, and the government's interest. Parental safety and bodily integrity are among the highest of private interests. Judge Price Borland refused to authenticate or even glance at several proffered exhibits, such as my Ring camera video footage and additional emails, while freely accepting Lodis's partially redacted screenshots that he even admitted were selectively compiled. By receiving one side's evidence and blocking the other, the court created maximum risk of erroneous deprivation. The judge also curtailed the petitioner's rebuttal rights, interrupting her mid-sentence by saying, "Stop, stop, stop," while allowing Lodis to testify uninterrupted for pages. Such asymmetry violates the core Eldridge notion of a meaningful opportunity to be heard. Federal case law like Bounds v. Smith and Lewis v. Casey forbids courts from handicapping a self-represented litigant solely because she lacks counsel. Yet Price Borland repeatedly relied on Antar's inability to marshal a perfect record, telling her that gaps in screenshot dates undermined her case, while overlooking the far larger evidentiary gaps in Lodis's defense. The judge's statement, "You guys need to grow up. This is just, come on," trivialized gender-based violence and applied a double standard. Lodis's admitted harassment was brushed aside as a mutual yin and yang, an approach Connecticut's own judicial branch bench book condemns as implicit bias. The court also failed to apply Connecticut's legislative mandate on coercive control under Public Act No. 21-78, also known as Jennifer's Law. Although the hearing predated the law's effective date, the statute codified existing due process jurisprudence, recognizing coercive control as domestic violence. The evidence of blocked calls, surveillance drive-bys, and threats of economic ruin met that definition. Ignoring those facts contradicted the legislative policy the Superior Court is duty-bound to advance. This is under the Connecticut Constitution, second article under the Separation of Powers Clause. The Connecticut Practice Book, Section 25-50, requires the court to allow parties to authenticate digital evidence. Antar offered to show the phone itself. The judge declined and then faulted her for not having the dates. Practice Book Section 4-4 mandates that self-represented parties receive reasonable assistance in introducing exhibits. The transcript shows the judge offered Lodis time to lay a foundation. "Let me have them," she said. Yet she rushed Antar's proffer, "I've made my decision," without the same courtesy. Department of Justice guidance instructs state courts to err on the side of victim safety and to avoid mutualizing blame. Price Borland's focus on Antar's supposed culpability contravenes that guidance and chills future victims from seeking help, a systematic equal protection harm. After hearing Antar protest that she doesn't want to be another statistic, the judge warned that she could come back if something new happens, effectively conditioning future protection on a fresh assault. Chilling a litigant's right to seek court relief by dismissing her petition on credibility grounds while admitting danger by ordering staggered courthouse departures violates the First Amendment right to petition for redress. By declaring mid-hearing, "I've made my decision," and then refusing additional exhibits, the judge signaled prejudgment. Federal courts have condemned such closing of the mind as structural bias in cases like In re Murchison and Caperton versus Massey. Structural bias invalidates the proceeding without showing of subjective ill will. The transcript is replete with the judge urging Lodis to elaborate, continue, while silencing Antar, stop. Such selective gatekeeping violates Rule 2.6a, which obligates judges to accord to every person who has a legal interest the right to be heard according to law. Taken together, misstatement of the legal standard, refusal to weigh unrebutted evidence of violence, and overt impatience toward the victim, Price Borland's conduct created a risk of undermining public confidence in the judiciary. Canon 1 demands the opposite: preservation of public trust, especially in sensitive family violence matters. Bottom line, Judge Price Borland's ruling was not merely an unfavorable exercise of discretion. It was rendered in contravention of Connecticut's Relief from Abuse statute, violated basic federal due process and equal protection guarantees, and ignored binding family law practice rules. Her conduct therefore furnishes powerful grounds for appellate reversal, a judicial review complaint, and inclusion in any federal civil rights pleading challenging the systemic denial of protection to domestic violence victims in Connecticut family courts. Almost immediately after the restraining order hearing ended, Matthew began sending me more emails trying to beg me to be back with him. He sent me a picture of a bouquet of roses via email and told me that he bought them for me and that he wanted me to be back with him. That was the start of him spending 2 straight months sending me money, gifts, flowers, and openly begging for me on Instagram and Facebook publicly for the world to see while I was actively in a relationship with someone else. After all that, a bunch of other stuff happened. I went over it in previous parts of the story. So if you want to go back and hear more details, you can go back and listen to parts 1 through 21 to be caught up. But basically, after March 21st, 2021, the next time that we came back to court was not until March 9th, 2022. And so I'm going to be going over all of the things that happened during the March 9th, 2022 hearing that were violations of the law and how they basically violated my rights again. And this goes along with the pattern that everything that happened before COVID was normal, and everything that happened in court from COVID on was corrupt. And after, when COVID happened, they shut the courts down for like a whole year, if not more. And when they opened them back up, they had installed all these like corrupt people and gotten rid of all the good ones. So follow me for the next part as I go into the March 9th, 2022 hearing and all the reasons why what they did there was a huge violation of my rights and the law.